Greetings, everyone. This is Russell Rucker, and I'm here for another constitutional talk. And today I'd like to talk about the purposes of why we even have a jury trial, which brings us to Amendment 6, which is part of our Bill of Rights. And it says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. And that's really the section here that I want to talk about today is why do we have a jury trial? You know, a few years back when I was still working, before I retired, I had a summons to be on a jury, and my boss wanted me to find a way to get out of it. And you know, there's no reason to get out of a jury trial. I understand it doesn't pay much. It does hardly anything. It's a pittance. But it's important for a fair judicial process. And if you have a bench trial with a judge, that's okay too. But the purpose of a jury trial is on more serious counts of a more serious crime. To be sure that we've got the right person. Now, if you're sitting on a jury and you've got generally 6 or 12 men, depending on which kind of jury you have, but let's say you have those 12 men. And I think the best example of this in film is 12 Angry Men. I think it came out in the 50s. It's an excellent film. And it shows how one person that just doesn't agree can sway eventually the entire group, because you have to argue over the crime. You have to bring evidence in. You have to discuss it. You have to go over. You have to mull over it all. And the whole objective here is to have a fair judicial process. Way back when we were dealing with Britain, before we actually had left Britain, Britain decided they were going to pay all the judges so that our colonies no longer were going to pay the judges. And this was really a point of contention, because if Britain was going to pay all the judges, they would be beholden to Britain. And we wanted a more impartial system. Now, one of our early trials, you know, with the Boston Massacre, you know, that was a trial in which we showed Britain, we showed England, that we could have an impartial system. It's a point of trusting the system to work, trying to get a fair trial. Some jurists think that it's okay, if they disagree with the law, to just find them not guilty because they don't like the law. Well, that's not proper use of a jury either. You're actually violating your oath when you do that, because your job as a jurist is to just simply find out, simply argue the objects in the case, argue the testimony out, and come to a verdict on whether the guy is guilty or not. It's not whether you think the law is right, or whether you think too many people have been arrested for this or that. You have to come to a conclusion for the betterment of the system. And if you have somebody that's been accused of, say, murder, you want to be sure that this guy that they've brought in, you have to be sure that he's actually guilty beyond a reasonable doubt, as they say. So there's a level of commitment here, and there's a level of how much we think this guy is guilty or not, and the prosecution has to prove the case. And you have a defense attorney there to defend the client, even if he does not have money, then one is appointed for him. And this whole purpose of this is so we don't have people that are innocent locked up in jail. Now, I don't dispute it does happen from time to time. We found proof later that this person or that person didn't do it. Somebody lied in court. Some evidence was found that showed later that he couldn't have done it. I mean, these things do happen. But that's why it's a right of the accused. A trial by jury, by members of his peers, people that would live around him and understand him. And that's really what's important here. Jurisprudence is important. It's important to have a fair trial. A trial that can be shown that it was fair, and that hopefully we have found the correct person guilty of whatever it is. And if he's not guilty, then the hope is that he's not found guilty, that he's found not guilty. You don't really find somebody innocent. You find them guilty or you find them not guilty. So there's no way of proving that they're innocent. But you find them not guilty by virtue of a reasonable doubt. Somebody has enough doubt. And that's why all 12 jurists have to agree. And that's why it's the best possible system. It's a difference between having one person hear the case, the judge, a bench trial, and having a dozen people hear the case. And there's a bigger chance that you will have it correctly done with more people than the less. And that's why a jury trial is so important. Our founders had problems with some of the bench trials that were happening in England. And as I was reading, out of textualism and originalism in our constitutional republic, it says in an area where the crime was committed. And why is that important? It's important because they were hauling people all the way to Britain, in some cases up to Nova Scotia, away from the seat of power upon which the crime occurred. So if you haul it a long ways off, there's less chance of having evidence produced that would find him guilty or not guilty. There's less chance to have witnesses come forward, because you're removing the case from the area in which a crime was committed. And there are cases, many of them, where we need to move the trial out of the jurisdiction because the jury pool has been compromised. So when you have a jury, let's say you have a 12-man jury, and then you'll also have 12 alternates in case some member of that jury becomes compromised and they have to bring in the alternate to replace him. That's why there are questions to be asked of each jurist as he comes in. As they try to see the jury, they have to choose who's going to be on that jury. All those things are important. I just want you to think about that for a few minutes. And keep in mind, our Constitution is important, and these rights are there for a reason. And the biggest reason these rights are there was because there was something in our past that showed us there was a problem with doing it any other way. And that's why our Constitution is so important. It does restrict power to from the federal government and reserves it to the states and the people. It also gives us a whole series of rights of the accused, the rights of free speech, press. All these things can become significant. Now, as you read through the Constitution, keep that in mind. And read it as if you're allowing the language to teach you, not looking for some kind of quirk to get out of something or to go after your political enemies. And that's really what's important here. But the power of a jury, the right of the accused to have a jury trial and to bring evidence, these are all important things. Well, thank you for your time today. We'll catch you next time on the next Constitutional Talk. And bye for now. Have a good day.